Senator Ramdeen.
Madam President, thank you again. And as I continue my contribution, I want to go back to the Director of Public Prosecution, Madam President, and a second statement that he made at the same hearing in relation to the way in which plea bargaining operates and how it can operate in our jurisdiction. And this is what Mr. Gaspard, Senior Counsel, had to say. I would not describe it as a fundamental shift. I would say it is a formalizing. This is in reference to this said piece of legislation. I would not describe it as a fundamental shift. I would say it is a formalizing of what would have obtained before, with additional safeguards for the protection of attorneys who may be involved in this plea bargaining process. So what you have is a scheme of, say, legislation which allows for the protection of attorneys while engaged in this process of plea bargaining. But if you compare what is proposed to what is currently in place, I would not describe it as a fundamental shift. You see, what the learned Director of Public Prosecution was saying, Madam President, is that we already had, since 1999, legislation to govern plea bargaining and plea agreement. And for 18 years, that legislation was in existence. And we had a gestation period where those who were in government over the various periods of time would have been able to examine the history over the past 18 years and be able, as no doubt the intention of the Attorney General has been, to strengthen the legislation, provide for what was not provided for, and to put in certain safeguards that were not present in the 1999 legislation. But, Madam President, one has to be very careful when one brings legislation like this that interferes with the powers that are already being exercised by the participants in the criminal justice system. And in that respect, Mr. Gaspard went on to say, I do not know, Mr. Gaspard went on to say, I would have, just to underline the point I would have made earlier about the fact that we already have plea bargaining informally. In the United Kingdom, I do not know that they have any particular piece of legislation dealing with plea bargaining. What they have is one provision, perhaps under the Serious Organized Crime and Police Act of 2005, which allows them to treat with persons who may become state witnesses in a particular way by giving them what is called a restricted use undertaking in written form, by way of a written notice that the information they provide and the evidence and so on would not be used against them. But every day I expect in all criminal jurisdictions, especially common law jurisdictions, you will find situations around the world where persons engage informally in the issue of plea bargaining. And just to bring to the attention of the Honorable Attorney General, Madam President, I think this particular paragraph that I'm going to refer to is something that the government will do well in exploring. And as to the backlog of persons, say at the prison, who may wish to avail themselves of the option of plea bargaining, that too can be dealt with in a particular way. I have always advocated that those persons who are in custody and who are unlikely to receive from the courts a sentence greater than the time they have already spent in custody, they may even now wish to write to the Director's office without the proposed legislation coming on stream. So, what is being made by Mr. Gaspard, Madam President, is that even without the plea bargaining legislation in place, if the government wishes to clear the backlog that is weighing heavy on the criminal justice system, one of the things that they can do, in addition to statutory reform such as what is presently before the Senate, is to embark upon an education drive for those persons who are incarcerated and explain and educate those persons who have been in the system for a very long period of time and have no way of getting out of it soon, that they can engage the Director of Public Prosecution, who has publicly indicated his willingness to listen to pleas of persons who are incarcerated for periods of time that may already be in excess of what they may be sentenced to when they come to be an active part in the criminal trial. And therefore we can voluntarily engage those persons in a process using the Director of Public Prosecution's Office and using his powers under Section 90 that can provide a way out, that does a very important thing, Madam President. It allows the administration to clear the backlog without actually going through the judicial system. Now, the Attorney General has said in piloting this bill, in piloting the motor vehicles bill, has announced to the public and understandably so, that there are going to be 2 new courts that are going to be set up with the family division bill that was passed. But one of the things that the Attorney General and any government and every administration, the previous administration and this one as well, has had to saddle with, one of the difficulties is finding courts to treat with the criminal justice system because we simply do not have enough courts. Now, having said that, Madam President, I must voice a certain degree of displeasure to understand that the government is trying as best as they can in the circumstances that they find themselves in to meet with the problems of the criminal justice system. There aren't enough courts, there aren't enough judges. But as we presently speak, I want to bring to the attention of the Attorney General, under correspondence to Senator the Honorable Wayne Sturge, dated the 16th of June 2017, under the hand of the Director of Personal Administration, Senator Sturge, in answer to a Freedom of Information request, was informed, and Attorney General, this is a matter that you have to deal with, was informed that we have a sitting judge of the High Court who has been given 3 years no pay leave. And now we are being told that he's been given 2 more years leave. So you have a sitting judge of the High Court on 5 years no pay leave. And the government is under a strain to fix the criminal justice system because we don't have enough judges. A judge that is on the seniority list, taking up a place in the judiciary on 5 years no pay leave. How could that ever be right? And on what basis this decision could have properly been made? When you have judges who are sitting as best as they can, doing public duty, day, weekend, public holidays, trying to clear up the backlog, and you have persons who are on no pay leave for 5 years, is a matter that must be addressed, Attorney General. Madam President, coming back to the issue that I raised before, I want to ask the Attorney General today to establish and bring to Cabinet a proposal to establish a forensic data officer for each division of the Trinidad and Tobago Police Service. That will be separate and apart from normal Trinidad and Tobago Police Service officers, so that in each division of the Trinidad and Tobago Police Service, we can have a designated qualified officer that treats with all of the scientific data, whether it be fingerprints, whether it be forensic ballistics, whether it be dangerous drugs. We can have an officer that can do that. The Attorney General indicated to the Senate when this bill was being piloted that there's a turnkey project to establish a new forensic science center. But that is going to take some time, Madam President. We need solutions now. So I want to ask the Attorney General today to establish 14 scholarships, 7 to the TTPS and 7 to the Faculty of Natural Sciences in the field of forensic science, so that before we build that forensic science center and find that we don't have the qualified staff to man it, that we can put things in place now. We have the money to do that. I want to ask the government today to put in place a plan to give 7 scholarships to study forensic pathology, so that we can have persons who can come back and give back to their country in a field that we need persons to do. Let us equip our country, not by simply giving out scholarships to any and everyone. Let us focus and target what we need and give scholarships to those persons. I was elated, Madam President, that the child who won the President Gold Medal this year, decided she didn't want to be a lawyer or a doctor. She wanted to be a forensic scientist so that she can come back and give back to the people of Trinidad and Tobago. The child who won the President Gold Medal this year. Madam President, in the little time that I have left, I want to, as the Honorable Minister of Agriculture did, I want to make reference to two real-life examples of plea bargaining in our country so that all of us on each bench here can understand the benefits that can accrue from legislation like this, but also the caution that we must have in passing legislation like this. Because this type of legislation, Madam President, has a public policy behind it of being or giving an opportunity to persons who have committed a criminal act against the country and allowing them the opportunity to get a discounted sentence, and there is a certain degree of public policy that is involved in that. And that balancing act between the prosecution on the one hand and the person who has committed that crime is one that we must very carefully balance. And I'll demonstrate it by reference to a matter that is very close to me, Madam President. I come from a village called Palmyra Village in San Fernando, and perhaps the only murder that we know of is a murder that took place in 2004. And the subject of the person who committed that murder is someone who benefited greatly from plea bargaining. And it goes to show, and I will demonstrate to you, Madam President, that while on the one hand we can implement legislation like this and say it will do well for the criminal justice system, we must also remember that the victims of the criminal justice system are also part of the criminal justice system, and they also demand justice as well. Madam President, in 2004, at the Langmore Health Foundation, Chandra Narayan Singh was shot and killed. And I'm reading here from the facts that were set out in Criminal Appeal number 12 of 2004, Sean Paris versus the state. Chandra Narayan Singh, Dr. Chandra Narayan Singh, the deceased, was shot and killed in her car at the Langmore Health Foundation, Palmyra, on the 29th of June, 1994. The case for the prosecution was that the applicant had been hired to kill her. On that day, he went to the foundation where she was employed, disguised as a patient. His arm was in a sling, and he was armed with a gun. He stood in the car park and waited for the deceased. As she entered the car, he walked up to her and shot her 5 times at point blank range. She died on the spot. The applicant did not dispute the prosecution's version of the facts. That is a real-life example of the facts that surrounded perhaps one of the most famous plea bargaining agreements in this country. Because a man who those facts could never support a conviction for manslaughter ended up plea bargaining and getting a deal of manslaughter, 30 years. He will walk out one day from this country. That is how dangerous it is to have legislation like this. We must be very careful about when we enact legislation like this, because we are putting the power in the hands of a few to exercise in the public interest. But the risk that one takes in doing that is that you can allow persons like Sean Paris, who should have faced the gallows, to one day have the opportunity to be back among all of us here. And one wonders, I have all the articles here, I can't go through them because of time. But when you understood what took place after Sean Paris was convicted and sentenced to 30 years, what took place thereafter were the people who planned that murder of Dr. Narayan Singh, then faced a prosecution that fell to the ground. And the witnesses in that, the people who planned with Sean Paris, got another plea bargaining deal. The 2 Morris brothers got another plea bargaining deal. And you know why I make a reference to that, Madam President? For this reason. One wonders today how the Narayan Singh family must have felt that everyone who was involved in the murder of that woman, that innocent woman who went to work that day, has walked on that indictment. And one day Sean Paris will be among all of us again because of plea bargaining. Madam President, I'm obliged. I want to make one more reference, Madam President, because what I have to tell the Attorney General about the bill is simply that I have put together 25 amendments, Attorney General, all of which I know you will take it on board. The most important of which I think is that in passing this legislation, Attorney General, I want to underline the caution that I understand why there are safeguards for those persons who are going to be engaged in plea bargaining. But the experience that we've had in the police service is not one that we want to seep in like a cancer into the prosecution of crime in our country. And therefore, I do not and I cannot advise that we pass legislation like this without putting in some type of mechanism in that legislation to ensure that if somebody does something wrong, that they must face the punishment for that, because the consequences are too great in our country. And the reason why I say that, Attorney General, is this. We had a prosecution in this country where 11 persons were convicted and sentenced to death for murdering Taku Budram and putting his head in a whiskey box at the Karani cremation site. 11 persons were sentenced to death in this jurisdiction. The main witness for 9 of those persons, subsequent to their conviction, the most wanted man in Trinidad at one point in time, Junior Grandison, has gone on statutory declaration dated the 1st of June 2011, by statutory declaration to His Excellency the President, and has said that the evidence he gave against those 9 men was fabricated. If the law didn't take its course or the facts didn't unveil themselves, you could have had 9 persons at least being sent to the gallows on evidence that was perjured. And that is the risk that we have, because Junior Grandison was another person who plea bargained his way out and sent 11 people to the gallows. We must understand, Madam President, that when you commit murder in this country, there is only one sentence that you can suffer. It is death by hanging. And when you give this kind of power to someone to plea bargain with persons who can be associates in a capital offense, you have to be very, very careful that we have the right safeguards to ensure that someone is not sent to the gallows and posthumously we realize that an error was made. We cannot afford that, because that sentence cannot be reversed. So I want to caution the Attorney General that we must be careful. This is legislation that can advance the aims of the criminal justice system. It was started a long time ago, as the Honorable Minister of Agriculture has said. It has passed through 3 and 4 administrations. We are at a time now when we can fix it. But our efforts will simply be in vain if we don't put in place the things that need to operationalize this piece of legislation. You are in government. The responsibility is yours. You have the assistance of the opposition. We have given you the suggestions. Bring the legislation that needs to be done. Operationalize the system from the bottom up. And like I've said more than one time, Madam President, you cannot solve crime in this country by passing legislation alone. You have to clean up the Trinidad and Tobago Police Service and the Trinidad and Tobago Prison Service. And as unattractive as it might be, that administration or this administration or any administration is not going to find a solution to crime unless you take hold of the police service and the prison service and get rid of those people who are corrupt in that system. We will help you do it. Propose the way forward. Bring legislation if you have to. Put together a special prosecution authority to deal with them, and we will support it. But at the end of the day, we find ourselves in this position that all of us are held victims every single day because you have a corrupt police service and a corrupt prison service. Get rid of the corrupt prison officers. Treat the prison as what it should be, a prison Not a place where you sit down and you're on the phone all day and you're talking all whole night on a cell phone. The cell phones don't drop from the sky, Madam President. So I would like to, I have given the Attorney General the suggestion, Madam President. I thank you very much.
Senator Ramkissoon.
Thank you, Madam President. Madam President, before I start my debate on the plea discussions and Agreement Act, I must say, just hours after experiencing a life-impacting experience from Tropical Storm Breath, I have to say thank God all members are here safely and sound, and the members of the public are also safe. Material things can be replaced, but life and good health and strength is something we have to be grateful for. So I had to pause and say thank God for that blessing. And maybe, Madam President, throw into the leader of government while I'm on that topic that we can leave a little early because of the Carney banks. I got this warning from the Met Office of that is high threatening, and I am from South as other members, so maybe you can look at.
I'm just waiting for a final official statement from the Minister of Works, who has just left, and once I get a report, we will act appropriately, and with good reason and with safety as paramount in our minds.
Thank you, thank you, thank you. Okay, Madam President, in relation to the plea discussion and plea agreement act, many has been said, or much has been said already about this, and I think the listening public, just to give them some principles about what this plea agreement or plea discussion will offer to them or to persons who may be a suspect or accused person. I found a nice guidance document from the gov.uk website, and it was labeled General Principles, and this is in relation. And I had a nice introduction in conducting plea discussions and presenting a plea agreement to the court. The prosecutor must act openly, fairly, and in the interest of justice. And for these reasons, Madam President, I will support legislation that will bring forward plea or, well, this is not new legislation, Madam President. This is to repeal the existing Plea Agreements and Discussion Act from 1999 and to bring about an amended version of that particular act. And there are principles in which is very applaudable, such as where the plea can act in the interest of justice, means ensuring that the plea agreement reflects the seriousness and the extent to which an act might have been committed. It also gives the court adequate sentencing powers and enables the court, the public, and the victims to have confidence in the outcome. It goes on to say that the prosecutor must consider the impact of a proposed plea on the basis of a plea on the community and the victim, and on the prospects of successfully prosecuting any other person implicated. The prosecutor must not agree to a reduced basis of plea which is misleading, untrue, or illogical. And also in this amended version, we're seeing that we would also like the victim to be involved in this plea discussion by the means of a victim impact statement. So, Madam President, according to the definition on the prosecutor, who is defined in clause 2, that is, the person has to be assigned from the Director of Public Prosecutions or an attorney at law authorized. And this person must ensure that a full and accurate record of the plea discussions is prepared and retained, and ensure that the defendant has sufficient information to enable him or her to play an informed part in plea discussions, as well as communicate with the victim before accepting a reduced basis of plea wherever it is practical, and as well as ensure that the plea agreement placed before the court fully and fairly reflects the matters agreed upon. Madam President, in the introduction by the Honorable AG in the Senate on this particular debate, we learned about the statistics that 21,000 High Court cases in arrears of over 15 years. We also learned that only 49% of the cases can be handled annually, and 51% of the cases are left undone. The explanation given was maybe because of delays in the number of cases versus the number of judges or courts and prosecutors. So, Madam President, we know that this particular act will not affect the present 21,000 cases, but we hope that the plea discussions will bring a reduction to the number of backlog in the system. Now, after 1999, we have only had 14 cases done or went to plea discussions. With that track record, we will not see any significant impact. So now, what can we do to encourage attorneys or victims or accused persons to go with a plea discussion? And that is where the difficulty lies. If we look at clause 24(3)(f), the accused understands that the court is not obligated to accept the plea agreement. So even though an attorney might reduce a charge or get a lesser reduced sentence for the accused or the suspect, there's nothing in this that says that the judge or the magistrate have to accept that recommendation. So now you might enter into a plea. We've only seen 14 cases, so we don't really know how this is going to work. What will lead me now to say this is a way that we should use? Because the court is not bound, the judge is not bound, and we have not seen a lot of success in the existing piece of legislation. And if you look at an article from the Express dated January 4, 2014, the title is Plea Bargaining Legislation Can Help. And it's a statement made, which I think it has a lot of truth in it. If you have low detection rates, and Senator Rambarat spoke about the percentage is less than 15% at present that was given by the police service. And these low rates, the article says, is due to witnesses being murdered or intimidated, the anxiety or fear that the accused will be tried and given a heavy sentence is not there. So the incentive of entering into a plea bargain to get a lesser jail sentence when you know there is the risk of receiving a heavy sentence is not there. So to see the operationalizing or the implementing of this particular system is something that would be interesting to know. Because, Madam President, unfortunately, Trinidadians and Tobagonians have gotten so brave, and we heard of the video mentioned earlier of the brutal mass murder, but there are also people who are so brave, Madam President, to post videos of themselves holding automatic machine guns, showing off their illegal substances or use of illegal substances. They are even so brave sometimes, Madam President, to show that they're defacing public property. And in the video, you will see them saying, call the police. So we have that culture, or I'm not sure when that culture has been encouraged, but we have now seen this in public domain. So it's not like Trinidadians and Tobagonians can access these videos, but internationally, people can see these videos and see this kind of lack of fear of being reprimanded for doing such an activity. it's almost like it has zero consequences. And Madam President, with a detection rate of under 15% and having such a brave population, it is something that these legislation will have some difficulty being implemented and really making a difference. And that's why the Honorable Senator from the government side, we need to ensure that the police service, we don't blame them, but ensure that they're doing what they are held accountable for. So, Madam President, I looked at an interesting book entitled Commonwealth Caribbean Criminal Practice and Procedure, and this was written by the Honorable and the late Senior Counsel Dana Sitahal. And she had an article or a chapter in this book on plea. And the book explained unequivocal plea, where the plea must not be open to interpretation. If a defendant says he is guilty with an explanation, this indicates that the plea is qualified. And there were some case studies, such as Lewis versus the Commissioner of Police in 1969, where there was a case from Grenada where the defendant pleaded guilty for assaulting a police officer, only to have the explanation given by the person who was accused reveal that she should have entered into a not guilty plea. And we also saw an example similarly in Baker 1912. This legislation, I've only seen provisions being made for a guilty plea, to enter into a guilty plea. I'm not seeing it where we can enter into a not guilty plea. You can say you're not guilty, but what's next? I'm not seeing anything in the bill before us about that. Well, okay, if you're admitting that you're not guilty or you're innocent, you have a continuous statement that you're innocent, that doesn't give that provision in this particular bill. It only is that guilty. And we don't want to have a forced person into it, because then there will be a nullity at the end of the day. So, Madam President, to move on to another point, in relation to the suspect. This is on page 5 of the amended legislation before us. And it says that a suspect means a person whom a police officer with reasonable cause suspects has committed an offense but who is not charged. I listened to the introduction on this because this particular suspect terminology was not separated in the 1999 legislation. So it's not really new, but it's new to this piece of legislation in this statement because it has been separated. I did seek more information on this, so I went to listen to the debate in the other place. And I learned in the committee stage there was a reference to a 2014 policy on the reform of the criminal law and procedure, and this particular document was used to decide why they should have a suspect separated in this format and what was the reasoning. However, this document is not available. I went to the Parliament staff library, and they were saying that this is not stage. So I don't know if the government can make this document available so members could really understand why we would like to include or separate a suspect and accused person, because an accused person is someone who is a person against whom a complaint is made or an information is laid, or a person against whom an indictment is preferred. And again, the suspect is someone who is not charged, but the police has reasonable cause to believe that they have committed an offense. Also, I did not really learn anything more on this in the committee stage, and I do hope other senators can share their their interpretation of this particular separation, because in my understanding, in my humble understanding, a suspect that is not charged, but he or she goes to court, and then a charge is laid later after discussion is done by the attorney who is representing such person. But if there's a scenario where you're a murderer or you're a murder suspect or an accomplice, how does that then work? Where's the link that these suspects will share truthful information to the police officers or to the attorney without having that fear of just making a statement that can be thrown out in court because it would be that you've been forced to make the statement? Also, if we look at clause 30, we will see that only an accused can withdraw from a plea agreement. A suspect cannot. Not exactly sure why. And we also learned, Madam President, during the introduction of the bill by the AG, we learned of the installation of cameras to allow for the recordings of agreements or plea agreements and discussions. And I had really thought this was based on a voluntary basis. But if we look at clause 10(1)(b), the accused person has informed the prosecutor in the form set out in Form 1 in the schedule that having been advised by the prosecutor of the matters referred to in paragraph A(1), he desires to represent himself and he agrees to the plea discussions being recorded. Is it that you have to qualify for a plea discussion recording and to the desire to represent himself? To fill out this form, then you need to do both to enter into a plea agreement, and that was not very clear. Because is it that I can enter into agreement without having a recording, or is it mandatory that I have to have these sessions recorded, as well as how long is it intended to keep these recordings? Is it a year, 10 years, until the end of the matter? That was not set out in the bill before us. Also, Madam President, clause 16 speaks about, and let me just quickly find it, and this is on page 12, where the victim is a child. And now a child in this particular bill is defined. Okay, this one wasn't defined. It wasn't the other one. So child is under 18 years, as we know from the Children's Act, which is 4601. And this clause 16 says that under the age of 14 years, a parent or guardian, or where the parents or guardians cannot be located, a person who has custody of the victim or who is responsible for the victim's care and support may make a victim impact statement on behalf of the victim. But Part B says, where the victim is a child, has attained the age of 14 years, the victim and one of his parents or guardians, or where the parent cannot be located, a person who has custody of the victim or who is responsible for the victim's care and support may make a victim impact statement on behalf of the victim. Why did we put in Part B? Because we already know that the child is under the age of 18. So clause A is sufficient to give that information. There's no need to separate it to put in Part B. Madam President, I would like to look at clause 4B, Part 3. And that deals with an undertaking not to institute charges against family members or friends of the accused or the suspect. And I would like to endorse Senator Cho's submission to add where there is evidence to sustain a charge. And that is because of case study R versus Herbert, 1992. It was held that there are pressures on an accused person and some factors may weigh in deciding how he pleads. In that case, the defendant was jointly charged with his wife for offenses including drug trafficking trafficking. He offered to plead guilty if the prosecution did not charge his wife. And that is why I would support putting when there is evidence, because you don't want to go through, again, a false plea because you want to protect your family. And again, this plea was found to be legally void because of this finding. Madam President, Clause 28 would provide that an accused person may appeal to the Court of Appeal where a court has rejected a plea agreement. And Clause 25 says that the judge or the magistrate has within 7 days to give a reason why the rejection was made, or the reason for the rejection of the plea. And in the bill, in Clause 25, they give you reasons for why a judge or a magistrate will find your plea to not be valid, and they would want to go to trial. Why then are we allowing this accused or the suspect an opportunity now to go to another judge to be tried? If we're trying to fast track or prevent backlog, is this not looking like you're trying up court's time by not going to another judge to give a reason that is in the legislation? I'm not really sure what was the reasoning for this particular clause. Also, Clause 25(3) doesn't really say how many times you can go before a judge to have a re-judgment on your plea agreement. Is it 10 times is the limit? Well, I don't think you can go before the court 10 times. You mightn't have the time, or even might not be heard more than once. But honestly, there's no limit to this. Clause 33 speaks about plea agreement inadmissible in criminal or civil courts. Now, this was a point that Senator Choate had made earlier in relation to evidence to the state, or what is the state gaining from plea agreements and plea discussions. And that would be that if you have evidence or you have given information, the evidence shouldn't be lost or only limited to that one particular case. For example, for serial murders or rape cases, you shouldn't just say, okay, this one person should be charged. And Madam President, I have to say that, just a little off point. I work in the industry, so crosstalk never gets to me because I just don't hear it. It's not a fault, it's just I really just don't hear. And so it's really hard to distract me. I don't know if it's the machinery or what caused it. It's that I just don't hear it. So if we would have a conversation, I just wouldn't hear. So it's very hard to distract me, Madam President, but apparently there was a message that really needed to be said during my debate. Unfortunately, it wasn't related to plea agreements, but it was related to a plea that I made in relation to the weather situation. And it was unfortunately that the Carney Banks was metal stripped. And we hope that after my debate, maybe we could have an early adjournment. So So in relation to this, back to Clause 33, which I found is a very, very good point, but I find the word not should be omitted. And that is on page 21. Evidence of the following matters is admissible in civil or criminal proceedings against the accused person who entered into a plea agreement or is a party to a plea discussion. So if this statement can resolve other cases within the system, it should be allowed. It's just like a simple situation, and it may solve the 21,000 cases in backlog. And I really like the phrase put forward by the Honorable Attorney General agreeing where we can agree. So we can agree on plea agreements and discussions. Utilizing the plea agreement and discussions are where I'm seeing the difficulty. And offenders need to fear the consequences of reprimand, and where they can get benefits from having a reduced conviction. Unfortunately, the Ministry of National Security needs to be more accountable for his reportees. And if we want change, Madam President, change needs to start with the prosecutors and the police officers for this piece of legislation to have a lot of workings in our system that we can all benefit from. And we definitely cannot just say we're going to pass this legislation or amendment to this legislation without putting things in place or correcting the systems that surrounds it, because it'll just be as good as a piece of paper is written on. So, Madam President, thank you for really indulging me this afternoon, and I do thank you.
Leader of Government Business.
Madam President, I have just been advised by the Minister of Works and Transport and the Director of Drainage that there is a very strong likelihood that the Caroni could overflow its bank very shortly. So in that context, I want to move the motion on the adjournment. Before I so do, I will just request of Senator Ramdeen, if you'd be so kind that you could pass the 25 amendments to the Attorney General for his consideration. So with that said, Madam President, I beg to move that the Senate do now adjourn to Thursday, the 22nd of June, 2017 at 2:30 p.m., at which time we will continue this debate on plea bargaining. And if time permits, we will debate the motion on the report of the committee that was set up to consider the amendments related to trial by judge only.
Honorable Senators, the question is that this Senate do now adjourn to Thursday, the 22nd of June, 2017 at 2:30 p.m. All in favor say aye. Aye. Any against? The ayes have it. This Senate now stands adjourned to Thursday, the 22nd of June, 2017 at 2:30 p.m. Members, if I could just caution everyone to be safe on your roads as you go home.